Hello, this is Grant Hughes of Grant Hughes Investigates on YouTube. Please hit that like button, share, and subscribe. Today's video is regarding two new documents that have come out, and we now know the answer of the private hearing. It was regarding, I guess there was two different issues that they must have talked about. They talked about the state's ability to examine Bryan Kohberger psychologically, and the other one was regarding letting Bryan Kohberger's family members be present in the courtroom during the trial, even before they have testified. So as we know, Bryan Kohberger has been accused of killing Madison Mogen, Kaylee Gonzalez, Ethan Chapin, and Xander Knodel on November 13th, 2022 between 4:08 and 4:20 a.m. And all of the evidence in the case points directly to Bryan Kohberger. In fact, I have seen no information that has any exculpatory value whatsoever, meaning, wow, that actually shows that he couldn't have been there. They've presented nothing, because there is nothing. For the sake of speeding up the video, I'm going to have ChatGPT break down the 17-page document. I've noticed that when I put out a video, a lot of times if it's a 20-minute video, you get 8 minutes of viewership. If it's a 30-minute video, maybe 12 minutes. So people don't really want to take the time to listen to a longer video, and I'm saying in general, a lot of you do like to do that. So I'm trying to make this a little bit quicker, and it'll give you exactly what the hearing was about and what these motions are about. And you'll know it in less than 10 minutes, all right? So the first one we're going to go over is the states requesting to be able to do their own psychological evaluation, and apparently one of their actual main expert that they were going to use had to suddenly withdraw for a good reason. It's not a conspiracy, everybody. I know the pro-burgers will say, ooh, they didn't use that guy because he was going to support the defense. We all know how it goes. Everything is a conspiracy to them, all right? So let's get started on the first one right now.
Introduction. The state requested a mental health examination of Kohberger under Idaho Code SS 18-207-4C, a 21-day extension beyond the rebuttal expert disclosure deadline, permission for the state's expert to conduct personality testing, exclusion of defense counsel from the examination room. Defendant did not oppose the right to a rebuttal exam itself, but disputed the scope, the presence of counsel, and the need for a deadline extension. The hearing was sealed to protect privacy and avoid prejudicing Kohberger's fair trial rights. Standards used: good cause standard, required for any extension of court deadlines ICR 45. Discretionary review: courts must act within legal boundaries and reasoned judgment citing State v. Herrera, Sanchez. Mental health testimony, governed by adversarial safeguards under ICSS 18-207-4. Procedural timeline: January 23, 2025. Defense disclosed expert opinions diagnosing Kohberger with autism spectrum disorder ASD, obsessive compulsive disorder OCD, attention deficit hyperactivity disorder ADHD. March 31, 2025. Defense disclosed 5 expert opinions for penalty phase. April 2 to 7, 2025. State and defense discussed logistics of rebuttal exam. State refused to allow counsel in the room and insisted on personality testing. Defense objected to both. April 11, 2025. State's first expert withdrew from the case. April 18 to 22, 2025. New expert retained. Reiterated same positions on testing and counsel exclusion. April 25, 2025. State filed this motion. Analysis: A. Extension of disclosure deadline. Court's ruling: limited extension granted until May 27, 2025. Reasoning: the state's expert withdrawal was truly unforeseen and excusable. The state didn't act with perfect diligence, but was not negligent. A full 21-day extension would prejudice the defense. The court balanced both parties' needs and emphasized that the state must complete its exam within 7 to 10 days, giving the expert approximately 2 weeks to write their report. B. Personality testing. Court's ruling: not permitted. Defense argument: their experts did not raise or test for personality disorders. Any such testing would exceed rebuttal scope and risk self-incrimination. Court's reasoning: personality testing goes beyond rebutting ASD, OCD, ADHD diagnoses. Risk of producing new diagnoses unrelated to mitigation phase. Adds unnecessary complexity and motion practice. The defense's evaluations relied more on collateral interviews, not Kohberger's self-reports, invalidating the state's argument for testing symptom validity. The court invoked Estelle v. Smith, State v. Payne, and Brown v. U.S., all reinforcing that a defendant waives rights only as to the mental condition placed at issue. Protective limitations. Defense cannot weaponize the absence of personality testing at trial. State expert may explain that lack of such data limited their evaluation. C. Presence of defense counsel. Court's ruling, counsel may not be present in the room but can observe via one-way video. Legal basis, Sixth Amendment provides assistance, not presence. Citing, State v. Payne, capital case upholding that only consultation is required. Estrada v. State, defendant must get advice from counsel, not physical presence. Hughes v. State, Idaho Court of Appeals, no right to counsel inside psych exams. Majority rule in U.S. courts is that counsel's presence may disrupt the examination's validity. State's expert noted, the presence of counsel would compromise the scientific reliability of the results. Video monitoring compromise. Both prosecution and defense may observe remotely. No interruptions will be permitted.
So as a recap, the court's final order is the extension of the deadline was granted to May 27, 2025, instead of 21 days post-exam. So the state has, I think it was 7 to 10 days to do an exam, and then 14 days after that, post-exam, which makes a total of 21 days. Instead of 21 days after the exam, that would be 31 days or so. The personality testing was denied beyond scope of rebuttal. And you also saw in there that the defense is not going to be allowed to use the fact that there was no personality testing done because the judge just now has denied the prosecution to be able to use that. So you can't then use that against the prosecution in court. The counsel present in exam room, denied. Sixth Amendment doesn't guarantee it. And then video observation is allowed, must be non-intrusive, one way only. All right, well, I hope the breakdown of the different rulings the judge made on the prosecution's ability to question Kohberger on his psychological, or do an evaluation on Kohberger. I hope that made sense. And now we're going to move on to the next portion, which was allowing Kohberger's family in the courtroom and even before they're questioned. All right, so let's listen to that one right now.
Order re. Defendant's family members in courtroom. Judge C. Kohberger, January 24, 3166 5. Judge, District Judge Stephen Hippler filed, May 7, 2025. Background. The court previously issued an April 16, 2025 order directing the state to submit, in camera and ex parte, a list of Kohberger's immediate family members it intended to call as trial witnesses. For each family member, explain why their exclusion from the courtroom was necessary under Idaho Rule of Evidence IR 615, whether they could be called early in the trial. The state complied with this directive. Legal framework. Idaho Rule of Evidence 615 Witness Exclusion Rule purpose, prevent witnesses from shaping their testimony by hearing others. Grants judges discretion to exclude witnesses from trial. Constitutional right, Sixth Amendment. Guarantees a public trial, which includes the presence of a defendant's friends and family. In Re. Oliver 1948, even for serious crimes, a defendant must be allowed to have their relatives present. United States v. Rivera 9th Seer 2012, family presence serves to ensure fairness, remind all actors of accountability, discourage perjury, encourage witness cooperation. While public trial rights are strong, they are not absolute. Waller v. Georgia, 1984. Court's analysis, the balancing test. The judge weighed Kohberger's constitutional right to have his parents and siblings attend trial against the state's interest in excluding witnesses per IR 615 to prevent coordinated or shaped testimony. Key findings. Family testimony is narrow in scope and unlikely to be affected by what others say. Family has already been interviewed. Recordings exist to check for consistency. High-profile case means the family likely already knows much of the state's case. The state itself preferred not to call the family out of order just to meet the exclusion requirement. Conclusion. The reasons for exclusion are weak. Kohberger's right to have family present outweighs the risk of compromised testimony. The court finds good cause to allow parents and siblings to remain in the courtroom throughout the entire trial, even if they testify.
All right, so the final order in allowing Kohberger's family members in the courtroom is presence of Kohberger's family permitted. Exclusion under IRE 615 not applied to family. State's request for witness control denied in favor of public trial right. All right, everybody, thank you all very much for watching. Leave a comment in the comment section. Let me know what you think. Hit that like button, share the video, and subscribe. And as I always say, everybody, until next time, be safe out there.